I've just gone live.
You've just gone live as I was laughing?
I did. That was the start of the webinar. That's nice. When the people come early, it's good. Thanks everyone who's joined already. We're just going to give them another 1 or 2 minutes, just to allow other people to join. I'm not sure whether the people attending can see other people joining, but I can see a big sort of flow of people joining now. So we'll just give everyone a chance to come on in, and in about a minute or so we'll kick off and get started. Thanks for waiting. Hey, Steve, can you hear the builders in the background? Can you actually hear that or not? No.
No.
Good timing. Okay, 1 more minute and we'll get started. Thanks for your patience, everyone. I reckon we'll get going. G'day everyone. My name is Peter Hayter, and I just want to say thanks very much everyone for taking the time to join us this morning here in Australia. I'm not sure if there's many people from overseas, but yeah, thanks everyone for taking the time out of your day to join us to just discuss employee misclassification in a bit more detail. As mentioned, I'm Peter. I'm here from Queensland, or Coupa. I'm the state manager up here. And for those of you who haven't heard of Coupa, it's a technology platform who's globally recognized as a global leader of business spend management. So from procurement sourcing contracts through to third-party supplier risk, expense management, all the way through to contingent workforce management. So the technology vendor management system, which helps organizations better manage their contingent workforce and services procurement labour. It's essentially managing the procurement of people. So it sits somewhere between HR and procurement. And I think that's often the situation or issue. It's often handled between both areas, which can elevate risk for businesses. I've worked across HR and procurement for the last 16 years in a variety of roles, from superannuation through to technology. And in recent years, I've worked in vendor management systems, helping organisations have visibility and better manage their external workforce. Employee classification is a wide and complex area. No doubt that's why you've all joined this morning. And due to a number of high-profile lawsuits in the recent years, it's received a lot of interest. And there's confusion around how to classify longer-term employees as casual, contractor, part-time, full-time. And as we've all seen, there's a number of examples of high-profile lawsuits like WorkPac, McDonald's, Foodora, APCO Group, which remind us of the importance of getting it right. And as Rachel just touched on before, it's about just giving it your best and having as much knowledge as you can. Got a really fantastic panel of experts assembled today, and they're going to share their insights and knowledge. We are opening up quite a lot to a lot of questions, so feel free in the sessions and times will be times to actually ask questions to the panels. So firstly, I'd like to introduce Rachel. She's going to give you a bit of background. She's the Head of Risk and Compliance for Asia Pacific for Impellam Group. G'day, Rachel.
Thanks, Peter. As Peter just mentioned, my name is Rachel Nolan. I am Head of Risk and Compliance for Impellam APAC. I currently look after 10 Impellam-owned companies in the Asia Pacific region, working in the contingent workforce management and entity compliance space, working across a wide range of industries. I work with companies to ensure they're regulating employment conditions according to updated legislation for that location and industry. I have a background in mining and construction, working across multi-billion-dollar projects in Asia Pacific, specialising in industrial employee relations for high-risk multinational complex project deliveries. I've worked in this space for about coming up 12 years now, working with the Impellam Group for the last 3 years. So I'm really excited to be here today to talk through the complexities of casual conversion and non-employee classification. Thanks.
Yeah, great. We look forward to getting into some of the detail of it as well. It's great. Next, I'd like to introduce Doug Edmonds. He's the Director for Asia Pacific for Guidant Global. Thanks for joining us today, Doug.
Thanks, Pete. And thanks, Rachel. So Guidant Global is one of the companies under the Impellam parent brand that Rachel just introduced. We currently have roughly $6 to $7 billion worth of contingent workforce spend spread out across the world. I started in the contingent workforce space, managing contingent workforce in what was pre the managed service time in 2006 in the UK, and have worked through the various generations and iterations of how contingent workforce is managed across Asia, mainly Australia, but also into various countries in the Asia region. Happy to be here today. I'll sort of bounce off Rachel a little bit and Steve as we go through some of the complexities in this particular topic. It's great to be here. Thanks, Pete.
Yeah, thanks, Doug. Yeah, and finally, but certainly not last, Steve Knapp, who's a Global Vice President of Coupa Contingent Workforce. He essentially runs the line of business for the contingent workforce solution across the globe. So yeah, thanks for joining us, Steve. And it's late, and I know this is your 26th meeting of the day, so appreciate you staying up from over there and joining us.
Thanks, Pete. And thank you everyone for attending. Happy to be here. It is 10 o'clock at night here, but that's fine. So as Pete said, I'm Steve Knapp. I look after CCW for the world now. I'm currently based in Ireland, although moving to my 5th country that I've lived in, the Netherlands, in a few months. My background is about 16 and a half years in the contingent workforce space from sort of every angle, having worked as a recruiter, implementing technology, implementing MSP programs. But for the last 6 years prior to joining Coupa, I actually worked for Brightfield Strategies, helping large multinationals kind of build their programs around how to manage contingent workers. So a lot of the examples that I'll talk about in today's session kind of draw from that, as well as working hand in hand with staffing industry analysts as they kind of evaluated the entire market and published a lot of their co-published a lot of their research papers with us. And here at Coupa, we have a number of organizations we work with that are that are quite large in scale, and I'll bring some of those use cases to bear as well. So happy to be here. Looking forward to having a conversation.
Yeah, great. Yeah, thanks, Steve. Thanks for joining us. Yeah, so the first topic today, which we're going to cover, is casual conversion. And we're going to pass over to Rachel to answer a few questions. So maybe first of all, we can start off with a simple one. What is casual conversion, Rachel?
Casual conversions and model clause, which was introduced in October 2018 to several modern awards and enterprise agreements in Australia. So the clause sets out an employee's right to request to change to permanent employment after working for a set amount of time of minimum months as a casual with a certain pattern of hours. So, for example, if a casual employee's worked for full-time low for a year, they can then request a change to full-time employment. If their pattern of work more closely resembles a part-time low, they can request a change to a part-time role. So the clause is important as it sets out or helps set workforce expectations while ensuring they know their rights. And it also then outlines the grounds on which an employer can refuse to change to a permanent role.
Okay, so they're able to refuse as well. Yeah, that's correct.
Correct.
And who needs to be aware? On reasonable grounds, yeah. And reading through some of the cases recently, you know, there's some really interesting stories around how that perception of time is really important as well. Who needs to be aware of it, of this?
So yes, this is going to affect both the employer and the employee who participate in ongoing casual employment relationships. So the key indicia of casual employment includes sort of irregular work patterns or uncertainty, discontinuity, intermittency of work or unpredictability. So it's important to recognise whether there is a true casual employment engagement happening with your workforce or whether this is deemed a permanent arrangement. So another key indicator of a casual arrangement will commonly reflect that, like, whilst employed, the availability of work for that employee is short-term and not ongoing, and that the employee's need for further work to be performed by the employee in the future is not reasonably predictable. So it is for any individual, both the employee and the employer, who participate in casual employment, but it's a key around the non-employee classification that's going to actually determine whether it is a casual employment relationship.
And I think that was the WorkPac case, wasn't it, where they mapped out for 12 months that this person was going to be working on I think anyway. Yeah, those cases where they are long time and it is a certain, you know.
Yes, WorkPac have come unstuck in recent years in Australia, which I'll go into more in detail later. But it's that issue of where they've deemed an individual casual and they've paid them casual loading and they've done the right things of putting it into the employment contracts and pay slips. But in actual fact, even if all their sort of paperwork and their administration is covering that it is a casual employment relationship, if federal court deemed that it was not, then you could then be faced with paying additional loadings on top of the loading that you already paid for the casual employment arrangement. Yeah,
okay, great. And just, it's great, we're getting some questions coming in on the chat. We'll have 5 minutes after each session, so after each topic. So feel free to start writing the questions now for the people that have joined, and we'll get to those and we can answer those, then we'll prompt those to the people. So the next question I was going to ask was, you know, what's the risk to organisations, you know, for non-compliance? What potentially could happen?
Yeah, so I guess most employees that hire casuals are going to be fraught with unexpected risks, particularly if those employees end up staying in the business for an extended period of time. So as I just mentioned, for an example, the recent federal court decision with WorkPac versus Rosado has again highlighted that employees may be entitled to leave entitlements underneath national employment standards, even if they've been appointed a casual and are paid loading under an applicable award or enterprise agreement. So this is an unexpected cost. I guess it's you can be hit with 6 years worth of back pay. For a small business, that's obviously going to be quite a big hit, particularly if there was multiple employees that were affected. Fair Work Ombudsman can also prosecute for non-compliance penalties as well. So I guess the main risk around this is the financial risk of going through a situation where it could potentially be challenged and that relationship be deemed permanent.
Yeah, great. Okay, thank you. So we have a question in the chat. If employee chooses to take conversion, does it have to be offered further down the track? This is from Lisa. If the employee chooses to take conversion, does it have to be offered further down the
So basically what will happen, it will be set out in the modern agreement or the modern award or the enterprise agreement that after duration of indicative months, then you can request for your employment to be transferred from casual to permanency. If that was requested, and the company basically needs to then work with that employee and work through that request, and if it is deemed that that person can then switch to permanency, then obviously that switch will then happen. Yep. So that person, that casual employee, will then become a permanent employee.
Yeah, great. Okay. Thanks, Rachel, and hopefully, Lisa, that answers the question. If it doesn't, feel free to write in the chat, and we'll continue to try to answer your questions. So we're going to move on to non-employee classification, and I thought, Steve, I'd ask you just around what do you typically see, in your experience over the years, organisations getting wrong with non-employee classification?
So I would boil it down to three kind of things that I see most organizations getting wrong, because obviously every country has different legislation and different kind of details and nuances to this, but in terms of behaviors and kind of what organizations get wrong are, number one, having fragmented ways of classifying and tracking all workers. It's very common that HR will say, I'm going to look after the temporary workers, and then procurement might say, I'm going to look after the professional workers or the statements of work or the independent contractors, or legal might say, oh, I care about the independent contractors. So the first thing that organizations get wrong is basically not having all of their non-employee workers in one place to be able to know how they're sort of consistently classifying. The second one is the sort of sweeping under the covers or hiding of temporary workers underneath a statement of work, and to kind of to pretend that they don't exist. Or I see this a lot in the UK right now, where with IR35 regulations being changed, you're seeing a lot of conversion of staff augmentation people to statements of work and then saying, oh, they're on a deliverable when they're not really, just to avoid taxation, which is going to come and bite them, I'm sure.
That happens here as well, quite a lot in Queensland. There's in Australia, but that happens over here as well, quite a lot.
Yeah, it's common. It's a practice that's been going on for a long time, and every time governments kind of put the screws to staff augmentation or try to put more regulations, you tend to see a ballooning of statements of work. So that's the second thing, is kind of allowing that to happen. And then the final thing is, and you see this all the time, is trying to classify people after they've already started. What organizations go, oh, well, we'll just let managers do whatever they want. And then, oh, I got to figure out what all these people are from a classification perspective. And when they're not all in one place, and when you haven't kind of sourced them and contracted from the beginning the right way, it's very difficult. Like, even if you say, you're actually classified wrong, and then it becomes difficult to unpick that when you've already engaged those persons. So it's not doing it early enough, not doing it all in one place, and allowing for bad behavior sort of for the wrong reasons.
And just to add on to it, I touched on at the beginning about that connection between procurement and HR. You're essentially procuring people. Does it sit with HR? Does it sit with procurement? I think that's another element that does create that complexity, as far as, you've got a business that needs a job done, so they just hire someone, but then, HR is told later, or, that's a really important piece as well, I think. So to have the visibility is really important.
Yeah, exactly.
Rachel, I was going to ask you, actually, we've got the questions. If you don't mind, before we keep on going on with this non-employee classification, we might go back. I don't know if you can see in the chat that there's a couple of questions. So Stacey's just asked back on the conversion. Yeah.
So looking at declining the conversion.
I might read out the question so everyone else, if they can't read it, then I'll say them in. If an employee declines the conversion, wants to stay as a casual, but the definition has a perm engagement, is a business still liable to additional leave entitlement?
Going back to sort of Lisa and Stacey's questions, in one of if an employee chooses not to take casual conversion. So one being that when the request is sent, that they have hit that period with that minimum time period that they are now eligible to request permanency. the employee may decide to decline that. They have sort of 21 days to respond to that request. Generally, what we would do is we would go back to that employee when that time frame lapsed again. So if they've chosen not to take it, say after 12 months, if they were engaged for a further 12 months or a total of 24 months, we would then send the same request again to make sure that they still were not wanting to convert over to permanency, or request to convert over to permanency. If an employee does decline, but then is challenged later on and the business, and it's determined that there was a perm engagement, yes, the business would still be liable. I think that if it's challenged in any case, that we've seen in recent court decisions, is that if it is deemed that it was a permanent relationship, there could be penalties of fines to go back and pay that permanency. I think that what we've then learned from this is that the court proceedings have definitely ruled that a casual employee can be deemed permanent regardless of the communication or the consultation that goes on between the employer and the employee.
That's interesting, isn't it? Makes it that more of a minefield, doesn't it? You know,
Yeah.
And Sophie's asked, is there a maximum penalty fine limit that a company can be charged under casual conversion?
Yeah, like we wouldn't be able to answer that, unfortunately. It's really up to the Fair Work Ombudsman and what that court ruling is. There's precedences set now and there's case law around it, but we would never be able to say with certainty whether there would be a maximum penalty or not.
Yeah, and I guess it's the number of people, the period of time, what actually happened. I guess there's a lot of variances.
Yeah, Australian employment legislations, as you know, is quite complex. So ruling out what could happen in the future around these types of legislation changes is, how long's a piece of string.
Yeah. So I was going to go, just back to you, Rachel, and explain the responsibility lies with the classification. You know, supply chain, is it the MSP, the end client? And I think, we were going to touch on the penalties. I think you've just touched on that a bit as well. I don't know if you can go further on that, but and Doug, feel free to chime in as well. So if you can explain.
I can talk through what we obviously do as an employer, and what we encourage employers to do to manage the risks around casual conversion. So we do encourage employees to regularly check the characterisation of their employment relationship, and make sure that it accurately reflects the predictability and continuity of the hours worked. So employers need to note that even if they pay their employees casual alerting, employees may still be able to bring a claim for annual leave payments upon termination if it's found that the employee was incorrectly classified as casual, as we've spoken about today. Regularly review your workforce to consider whether any long-term casuals are more appropriately classified as permanent employees. So that basically means applying the casual conversion clause that's already in the modern awards or enterprise agreements. Educating your internal HR and recruitment teams, whether that be HR or procurement. So ensuring that those that are responsible for hiring staff are actually in your organisation actually aware of the casual employment indicia and the factors that would influence the genuine casual employee morphing into permanent employees. We have seen obviously hiring managers coming in and hiring casuals on a 24-month assignment where as a casual where they're not skilled or have the knowledge around what this casual conversion placement means and that it is a true permanency position. So definitely educating those that are responsible for hiring those personnel are aware of the law and the clause that's come in. Always notify your casuals. So moving forward, whenever you hire any casuals, give them a copy of the new casual conversion provisions when they start work, setting diary reminders before the 12-month anniversary of their first shift, so that you're making sure that you're sending out that communication when it's required to do so. Whether or not they are regular casuals, you need to give them a copy of the new provisions for 12 months of their within the 12 months of their first shift. So we also recommend keeping evidence trail of everything that's sent between the employer and the employee. It is a compliance obligation and it may be called upon in an investigation. So we definitely recommend that you keep as much information as you can and around the conversations and communication. Ensuring the enterprise agreements and contracts are clear about casuals, to reduce the risk of employees claiming that they are not casuals, and ensure that your contracts or your enterprise agreements include a detailed definition of a casual employee, as I mentioned earlier. I think that that's a key point in all of this. It is complex, and it is unprecedented with how it will move working forward. But if you've had a clear definition of what a casual employee is, I think that it really minimises that risk. There is a requirement to separately identify the casual loading. So casual loadings need to be separately identified in employment contracts and pay slips. Expressly stated that to be paid in lieu of paid annual leave or other entitlements, which is the same as set-off clauses. So reviewing your set-off clauses in contracts to ensure they meet or to endeavour to ensure they meet specific needs to increase the chance that casual loadings can be claimed back in the event of a challenge. As I mentioned earlier, when a casual conversion request is received, employees need to respond promptly to those requests. So if an existing casual requests that they'd like to convert to full-time or part-time employment, a consultation period with them about what they're looking for, considering your business needs, and think about maybe getting some advice either for your internal, external legal team for going back and agreeing to their request or not. So I did mention earlier that there is a grace where you can refuse that request, but it needs to be under reasonable grounds. So we definitely recommend getting sort of internal legal advice, or from your industrial relations committee, whatever it is, to make sure that you're sort of meeting those reasonable grounds. And there is a time period that you need to respond to them in 21 days as well. So again, keeping that paper trail of that consultation is definitely important when responding to the casual conversion requests. And I guess we're reviewing your systems and practices, no matter how good your contracts are, if in reality you treat a casual employee like a permanent employee, there's a real risk. And a court may decide they're entitled to pay leave, and it could be on top of the casual loading that you've paid them. So in short, there's no real simple answer to the question of how to minimise the risk, but we believe that good tracking systems definitely help if you implement strategies to keep on top of what that relationship looks like, constantly reviewing the engagement and making sure that it is a true casual engagement, and keeping track of that communication definitely minimises that risk.
Yeah, great. Thanks, Rachel. And Doug, did you want to add anything onto, there's obviously penalties or potential penalties as well. In your experience, did you want to add anything to this?
Not in terms of the actual legalities. That's certainly Rachel's area of expertise. I guess for us, it's about taking that expertise that Rachel has and determining how we can audit that through an organization's current systems and processes. And that's really where, where it's if you have a decentralized hiring system that Steve was talking about a little bit earlier, how, how do you go about ensuring that in that maybe a multi-site or decentralized system, how do you go about ensuring that we can monitor and maintain a level of compliance to the legislation that Rachel is talking about, and provide you with an audit trail of what has happened. And also, it's not just it's consulting up front, but it's also being able to actually go and record what you've done all the way along. So if you are in a position where you have to demonstrate that you feel you've done all the right things, you're able to actually draw up all the paperwork that can back what you've done, and back that you've done everything in the appropriate way.
It was subtle.
I really can't add to Rachel. Rachel's a subject matter expert in all this, so I really can't add to what she said. What I, where I guess our expertise comes into is being able to provide you with that consultation up front, setting up the systems and processes, and then providing you with an audit trail on the back end when and if required.
I think Rachel touched on it a few times. The audit trail and documenting and making sure you've got clarity on notes and documenting everything seems to be the key part of it as well.
Yeah, and that's really, Pete, the marriage between Rachel's subject matter expertise and the Coupa platform, right? The Coupa platform has with Rachel, we set up the systems and processes all the way along, and the checks and balances. Having something that can underpin that, and we can easily technology that we can easily draw all that information from, makes it that much easier to manage this.
Yeah, Steve, did you want to add in on this? Or?
Yeah, I mean, that's exactly right. Like we can't exist on our own. We need experts kind of configuring the system the right way and managing the data and kind of curating everything along the way. But I think of us as kind of the backbone of information from beginning to end, right? So you guys have all touched on making sure that consultation is done up front. We call that guided buying, but making sure that all of those the questions and answers that you might ask, or the audit trail of the decision that was made at the beginning in terms of classification, is having a way of recording that, making that auditable in perpetuity, and then tracking the entire life cycle of that worker, and understanding what they've done, who they've worked for, how much have they worked. So having your time and your contract and the sourcing and classification all in one place, like I said, I see it as kind of an end-to-end backbone, which enables you guys to provide that service and help your end clients, feel confident that they're able to defend whatever decisions they're making.
Yeah, great. Thank you. And back to you, Doug. Oh, actually, we've got the question. Sorry, there's one of the attendees that asked, can you recommend a website? I'm assuming this is going to you, Rachel. Recommend a website, or rather that we could get clause template RE 25% in lieu of entitlements.
Look, we would always recommend that you revert back to the Fair Work Ombudsman and the National Employment Standards to direct all of your sort of contracts or agreements out of. We would then recommend that you would seek advice from your internal industrial relations team or internal external legal advice to make sure that those clauses or legislative changes are then reflected in your agreements and your casual contracts.
And just so everyone knows who's attending, we will be putting up everyone's contact details afterwards. So if there are questions that you want to take offline and ask, or if you'd like to engage further, happy to do that. There'll also be information sent back out to you with the recording and things afterwards as well. So, but we'll keep on kicking on. Doug, I was going to ask you, in relation to particular industries, are there any that you think that need to pay particular attention to these sorts of things?
I mean, yes, there's ones that I think should, absolutely. They're not always the ones that we hear from the most. And I think that, we've all kind of touched on it a little bit, and that's the multi-site, decentralized, multi-hire, high turnover model, which is absolutely necessary in certain segments of the market. If you're in manufacturing, if you're in mining or agribusiness or any primary industries, that is how your business model operates and how it has to operate to maintain profitability. And those are the industries that I think probably should be the most concerned about what happens, and that's and most concerned about when they have a site that's maybe a little bit more remote, what that hiring manager is actually doing and how they're promoting themselves and how they're working with their contingent workforce staff. If you don't have a sight of that, a visibility of that, especially in Australia, do you know what's going on there? And so for me, that's where really a lot of these discussions should take place within those environments. It's interesting though, Pete, that most of the interest we get in what we do comes from centralized head office CBD environments with a lot of IT people in them, because they want to get visibility over what's happening in their IT spends and what kind of consultancy they get. And really that is less of a risk play and all the stuff that Rachel's talking about, because usually that's well over award, and they want it becomes down to the value and how can we actually decrease our costs, as opposed to how do we there's less of a need to sort of manage their risks. So yes, it's interesting that the buyers aren't always the ones that we feel probably should be looking into it the most.
And I think having dealt with lots of different organisations across government, mining, natural resources, all sorts of finance, if it's too hard, it's a human trade, isn't it, just to avoid it? So it's almost too hard. So let's just try to do our best with what we can. And but I agree with you. I think there's organisations and industries that probably should be focusing a little bit more on things and aren't necessarily.
Yeah, there's a way that things have always been done. When we talk about these business models and how they have to approach it, and that's that decentralized, high volume, many contractors, fluctuations of contractors required. There's a way that's always been done. There's a lot of personal relationships at stake. I think the key to think about here is not just the law as it currently stands. It's the stuff that Rachel was talking about most of it is unprecedented. And there is a whole lot of, potential gray area in how some of these contracts with contingent workers are taking place and what we call non-employee and the non-employee workforce are taking place. Yeah. And at the end of the day, we don't, sometimes nobody can tell you what is going to happen tomorrow in a particular case that could be, brewing right now somewhere in Australia. And that to me is probably the most concerning element of all this is that huge gray area within the current structure.
Yeah, no, I agree with you. And with that focus on risk and how to manage and how best to manage the risk, I was going to come over to you, Steve, and just say, with a large organisation using a lot of non-employees across multiple sites, like Doug mentioned, how could you suggest, or what would you have seen as best practice to best manage these risks?
So I think if I think back to the very first use case of when CCW was created 20 some odd years ago, it was actually about managing risk. It was a slightly different use case in that what was happening is people in a large company with multiple sites, oftentimes multiple sites in the same city or same town, same area, people would get fired from one site because they did something wrong, walk across the street, and then go start working at another site. And so the fundamental premise of why CCW exists today is the idea of tracking a person, whether they're coming from one agency or another, or whether they're on one site or another. So, people's names change, people misspell their names, and you, for privacy reasons, often can't get a lot of pieces of personal information. So, having a way of tracking a human being when they're not your direct employee, but rather coming through an agency is kind of fundamentally the first thing you need to be able to do when you're a large multi-site organization that has lots of contractors coming in and out. And whether it's to make sure that you track how long they've been there and what they've done and how many hours they've worked, or what how they've performed and whether that you've kicked them out, or whether they have all the right certificates or the right types of contracts in place. That's fundamentally the first thing. So it's why our system exists. And if I scale that all the way up to some of the largest organizations in the world, their HR department and procurement get together and say, we are going to set up a global policy that says, if you're going to walk in the door, if you're an employee, you're coming through our HR system. If you're a non-employee, you're coming through, in this case, CCW. And our largest company we work with has 120,000 people at any one time going through CCW because they enforce that rule, right? They enforce it by ensuring that you don't get a badge unless you're in the system of record for non-employees, right? Just like you don't get a badge as an employee unless you're in the HR system. And like I said, because the spectrum of non-employees is so broad, and because people are coming back and forth from potentially different agencies or to different sites, it's really important that you have a source of truth and a way of ensuring that you capture all those people. So it's kind of tying access with ensuring that the suppliers give you the right data and have one place for it.
There's a great example of that I had a number of years ago. There was a finance industry organization in Singapore that had a direct contractor that stole some IP, stole some information, was removed from site under that direct engagement. And then because they had the VMS, they were able to see this person come back through a statement of work through a larger consulting firm a few weeks later, and otherwise that person would have had the same access to the same rights and all that sort of thing. Yeah, so yeah, I agree and understand exactly what you're saying.
Just as another example, I did an audit at a bank in London, and they thought their HR department thought they had 10,000 temporary workers. According to the badge system, there were 60,000 active badges of non-employees. The truth was somewhere in the middle, but because they didn't have a VMS to track all those and be the source of truth that activated and deactivated those cards, they had no clue. Yep. And lo and behold, they had IP walk out the door and show up at a bank down the street, and it was a contractor that took it. You know, I mean, these kinds of things happen all the time. You know, there's all sorts of different risks when you don't have your arms around your non-employed workforce.
And Doug, I'll come to you in a second, just asking around the you know, how an MSP can help manage that risk. But there is a question. There's two questions. So Lisa, we'll get to your question at the end of this little session. There's an anonymous attendee who's asked, how long does it go for? And will be recorded and sent out later. We will be, so happy to share it. So if you do need to drop, that's fine. But yeah, just wanted to answer that now in case you are in a rush to head off to another meeting. So Doug, I was going to come into you and just ask around, you know, how does the MSP, managed service provider, support and help manage these risks as well?
Yeah, I touched on it in the beginning, Pete, and you know, really, and it's funny how our screens are set up. You know, I'm kind of in between. On my screen, I'm in between Rachel and Steve, how I'm set up. And that's really what the MSP does. It's I don't know if you set it up that way, Pete, on purpose, but really it's about, you know, taking all of Rachel's it's taking you know, it's taking the SMEs, and it's not just Rachel, you know, it's health and safety, it's invoicing, it's, you know, it's all that information, it's cost, it's legal, it's taking all our SMEs that sit within the Impellam group and creating all the things we just talked about, a process and a systematic approach to how organizations go about hiring non-employee labor. Let's call it non-employee labor, you know, contingent labor, non-employee labor, and helping them create that systems of checks, balances, and then we marry that with a Coupa technology, and that's where we come in and we manage that process on behalf of the client. So really, it's a management function in the middle. It's an audit function. We set up the cadence of reporting requirements, the data sets that you or an organization thinks they might need, or that we think they might need to support their program around contingent workforce hiring. It's about red flagging anything that we see as an anomaly, any potential risks we see with how you're procuring your supply chain. You know, Rachel talked a little bit about, you know, what's, for instance, a very simple example, what's required on a contract arrangement with a worker, or what's on a timesheet. You know, those things have to be pretty specifically spelled out. So we are the check and control of that process once it's, you know, so we create it up front, we apply like a Coupa technology to it, and then we provide the checks and balances as we move along. So that's in a nutshell, that's kind of where we sit.
Yeah, and I think with working with you on different engagements, one of the things that I do like about Guidant is that you do that phase out approach as well. You're happy to come in and upskill the existing and hand it off as if organizations are wanting to take it on board. It's not you're there trying to just come in and sit there for years and just do this service, you know. So I do like that about Guidant, that you are happy to do that phase out model as well over a number of years and upskill the local, you know, whichever the organization is.
Yeah, well, you know, the market's changed a lot. I mean, Pete, we used to, you know, as we know, it used to be an in the box, you know, how we used to sell it, you know, how the first generations of some of these programs, how they occurred. It's moved, and so it's a lot more fluid now. You know, if you look at just how the award system works in Australia and the incorporation of that over the years and how we've had to do it, we've had, you know, we have to adjust to the marketplace a little bit, and it's not. The risk, it's interesting because the risk is not just with big organizations, it's anybody who has, you know, even just a handful of casual workers, they're equally, if not more at risk than some of the big organizations. And so how can we help them manage it as well? So we've had to look at how we operate and how we can actually support those types of businesses.
That was I mean, it's cheesy, but it's a good segue because the next question was around those organizations that don't have an MSP or don't have a VMS, a vendor management system, a technology platform, or your sort of support. How does a small organization, and I'll probably go to Rachel on this one, around the use and management of these non-employees across the organization. How would a small organization manage the risk associated with some of the things that we've talked about? I think you're on mute.
Sorry. Yeah, I guess as I touched on earlier, what we recommend is looking at the way that you track your business. So making sure that you're keeping even internal systems, what that looks like if you're not going to go out to use a VMS system or MSP, if you're using your own CRM, or if you're having something that's quite manual, making sure that you've got a centralized database that keeps track of all your employees or your non-employees in your casual cohort. I think constantly reviewing your arrangements with those casual cohorts to make sure that the evolving nature of the business is still capturing updated legislation. If you don't have a dedicated source that you can go to talk about industrial relations activities, I would keep yourself abreast with any changes going on under Fair Work and the National Employment Standards. So there's particular sort of alerts you can set up with the Fair Work Commission so that you're constantly keeping it updated with legislation changes to make sure that you're rolling them out into your contracts and agreements. A question, did come in around that. If you have then gone and updated your casual contracts and want to issue updated ones, what will happen if an employee doesn't want to sign a new contract? So changes of this sort we would see as procedural changes. They're not fundamental changes to a contract that are going to affect someone's remuneration or notice period or duration of the contract. So we would look at them a little bit differently, that it is an obligation for an employee to agree to that. However, spelling out and changing any obligations in a signed contract does change the agreement between the parties. So we would recommend any sort of amendment agreement that's given to an employee if there are any concerns, to basically manage those expectations with the employee, to discuss concerns with them, understand why they're not willing to sign on the new agreement. The unilateral changes can be problematic with employment contracts. So it's basically just being able to give the opportunity to the workforce to be able to look at their concerns with any sort of updated amendments. But as I said, procedural changes like this should be fairly straightforward to discuss with an employee. They're the things that I sort of would recommend.
Yeah, sorry, there's a 2-second lag on the call. So if someone doesn't want to sign that, it's just an agreement between two parties, isn't it? So if they say, look, this isn't, they've, really is just, well, if you don't want to sign it, and it's something that the company or the organization's agreed to as a fundamental rule within the business of being employed by them, it just comes down to, well, we can't employ you then. Is that as simple as it is? Or, if you can't work it out?
No.
No?
Unfortunately not in Australia. That's why we recommend that transparency, that open communication between the employer and the employee, to having a discussion around those concerns and trying to address those concerns. At the end of the day, we also want to make sure that the casual cohort are happy and they are comfortable with the conditions that they're signing. So there is a agreement already in place with both parties. If one party obviously wants to come and change some of them, and you'll actually make changes to that contract, and there is a barrier there, you can't force that employee to sign that new agreement. Rather still would recommend working with that employee to resolve any issues that they have with signing those unilateral changes.
Yeah, okay, great, thank you. Yeah, it's endless, isn't it? Well, I was going to go to Lisa's question, but you've answered that now, so that's great. It was really just going to open up, that was sort of the session for now. We've got 12 minutes left. Understanding most people like to head straight off and make a call before a meeting. Is there anything else? Are there any other tips or anything that anyone wanted to answer from the panel, just in closing it out in managing the risk around these non-employees? No trouble if not. I think we've covered a lot, but if not, I'll open it up to the...
Yeah, I guess that I just wanted to touch on the fact that, as we've just sort of recognise that this is the tip of the iceberg. Employment legislation in Australia is highly complex and it is ever evolving, and this is just one very small area of what it looks like to hire a contingent workforce and manage that contingent workforce. As Doug mentioned earlier, that there's a variety of SMEs that come into that workforce management, and myself sort of being across this space is just a very small area of what I do in going into OH&S and going into the sort of financial remuneration stage as well, is that anything that sort of can happen in casual conversion or non-employee classification can have such a ripple effect on so many different strategies in the business, or so many different disciplines and areas of the business, and so it can affect ongoing employment with that contingent workforce. So having a centralized database or a managed service provider to be able to then execute sort of compliantly across all areas of the business and understand where casual conversion then may go into OH&S areas of the business or go into financial and remuneration payroll part of the business. Really having that one place to go to so that you can make sure that you're compliant across the board is I guess, really, really effective.
Okay, yeah, that's great. And Doug and Steve, you know, I'm not sure if you wanted to add anything. We do have another question, so happy to go straight to the question.
Yeah, go to the question.
Okay. Yeah, so the question is probably aimed back at you again, Rachel. Could you please clarify, is emphasis on the employer to offer or the employee to request? Again,
so the employer, the employer is required to I guess communicate that the employee has then hit that time frame that they are able to request. So it does need to be on the employee to request, but the employer has a responsibility to advise that they've now hit that period to request. So whenever that time frame has come up, according to the Modern Awarded Enterprise Agreement, the employer first needs to advise the casual employee, as well as on first day of assignment, that they are available to request casual conversion. And then the emphasis is then on the employee to then make that request. If it hits that 21-day period and no request has come in, it is deemed as though that employee has not requested to convert to permanency, and you can sort of, I guess, rest easy for the following 12 months. But as we've discussed today, there's more of it that comes into it than just that initial casual conversion request, that to make sure that you actually have a true casual arrangement in place. It's obviously fundamental to make sure that you're minimizing that risk overall in the future, whether requests have come in or not.
Yeah, great. Yep, thank you. If there's any other questions, please type them now. I'll start closing up the session, but if there are any questions, we're happy to answer them in the last few minutes that we've got. And there's nothing coming through unless people are typing quickly. So yeah, I just wanted to say thanks, Rachel, Steve, and Doug for taking the time. I'd like to thank everyone for taking some time out of your morning or evening to join and to hear. I find it a really interesting topic, and because there's so many variables and so many unknowns and gotchas. So yeah, I just want to say thanks everyone for sharing your knowledge. There's a question which is good. I'll just put this up on the screen as well for people to document if they want. It just says, yeah, Lisa says, thanks everyone, it's a minefield, and it certainly is. Yeah, put everyone's details up there. If you would like to reach out to anyone, feel free to afterwards. Yeah, please get in touch with us. We'd like to stay in touch and deal with you more. If there are any questions that come out, we are going to send out the recording of this to you as well, so you'll have it documented, and we'll PDF all the questions and share them back to you as well. So yeah, that was really it. I just want to say thanks very much everyone for joining today, and have a good rest of the week and year, and hope everyone's staying safe and well and wherever you are in the world, and we look forward to maybe dealing with you again in the future. So thanks everyone in the panel as well.
Thank you.
Thanks, Pete.
Thanks, Pete. Thanks, Rachel. Thanks, Steve.
Thanks, guys.
Do I just end the meeting for all? Oh no, I'll stop it.
Yeah.